We talked about FINRA requires all of this registration paperwork, termination paperwork to be filed electronically through the CRD. We know Form U4 is the filing that you will do to become a registered rep. It is required that your member firm retain your manually signed Form U4 and any amendments to the disclosure information found on Form U4 and make them available promptly upon regulatory request. So if FINRA should come into the firm and ask for books and records, they would have to make the manually signed Form U4 available for them to see promptly. We talked about at the very beginning of this section, part of the registration requirement is that you get your fingerprints done, and that when you leave the firm, terminated individuals, the fingerprints of them must be kept by the firm for 3 years. It's also true that member firms must keep all Form U4 filing information for 3 years after a person's employment was terminated. So if an individual is terminated, Form U5 is filed, and then fingerprints kept, all records related to that person's employment, including their U4, any amendments, all of that's kept for 3 years. I know I've said this before, but you're going to want to keep track of a bunch of different dates, so I'm trying to help. A customer, let's say it like this, a former customer of a firm, records related to the former customer must be kept for twice as long, for 6 years. So this rule actually comes up in a much later chapter, but these are two similar types of rules that I don't want you to confuse, which is why I put them together. So if an individual that was registered leaves the firm, all the paperwork related to their employment is kept for 3 years. But if a customer leaves the firm, the customer information must be kept for 6 years. FINRA writes test questions. They make a data bank of questions. They administer the exam. So recently, FINRA did a poll of all currently registered reps, asked them what their most important job functions are, and published a new examination outline. So the examination outline does reference new rules, which of course are covered in this course. Much more law than there has been historically, although the overall job hasn't changed over time. So the content for the course, the core content, really product knowledge, the way the securities industries work, stocks, bonds, all of that, that's all the same. It's just that the law, there's more regulatory requirements tested on the exam today than there was last year, than there was 10 years ago. So you're going to go in, take your test. Remember, I always suggest on your scratch paper or erasable boardish thing, you write across the top, I will pass. And then when you pass, make sure that you submit testimonials so that we know how well you did, because I actually really love my job and I only do well if you do well. So please, please, please let me know how you did. Now, you're not going to fail, but if you did, you need to know the procedures and how it works. So if a person does not pass the test on their first attempt, they cannot retest for 30 days. So they have to pay another fee, and then their window won't open again for 30 days. If a person doesn't pass the test on their second attempt, the same thing would happen. They would have to wait another 30 days before they could retest. So they'd be feverishly studying, submitting questions. Really everything you need to know is presented in the course. It's just, sometimes it's a lot to know. So make sure if you have any questions to always ask us questions. If the third time someone attempts to take a securities exam, they do not pass, FINRA requires that they wait for 6 months in between taking their third and fourth test, or their fourth and fifth test. So 6 months or 180 days, it's the same thing. They'll say it one of the two ways. So you do need to know these rules. So 30 days, so first attempt, wait 30 days. Second attempt, wait 30 days. Third attempt, if a person does not pass, they have to wait 6 months. And that's going forward 6 months every time after that. This is not going to be you. Success starts here. You are passing your test the first time. You just have to study when I'm not talking to you. You just have to promise me that you do all the things that we recommend. You take the practice quizzes. You don't memorize your answers. You read the key facts, and then you read them again, and then you read them before bed, and you dream about them. I'm not kidding. It works. There's nothing more awful than dreaming about securities, but when you go and take and pass your test, you'll be so thankful. And you'll hear my voice in there. It's always a good thing to hear my voice. I'll fade eventually over time, I promise. But this is all based upon student feedback that such things will happen. FINRA considers all of the qualification exams that it administers to be highly confidential. So of course there's a tutorial at the beginning of the test, and then you have to basically promise that you're not going to steal the test. Of course not. Why would you ever try to do that? So you can't remove any questions, you don't have a camera. That's why there's that erasable whiteboard, so that nobody actually can leave with a piece of paper with anything written down. Some facilities will wand you like you're, I don't know what they're doing. Take off your hat, of course, no watches usually. Every testing center has slightly different rules. Some take your fingerprints, some take your palm prints. Just know this going in, because you're going to be nervous. There's no way around that. Know you're going to be nervous. Know they're going to make you feel even worse. It's honestly worse than TSA most of the time. They'll give you earplugs in case the person sitting next to you is not taking the same test you are, and they're seeming distracted. So of course the test is confidential. You cannot remove anything. You can't get assistance. That's why they won't let you take your cell phone in. You can't send any content questions while you're taking the test. I actually suggest that you just leave all of your study materials in your car. And then, you can take your purse, any ID that they require you to have. Usually they have a locker that you can lock up your stuff. Not all facilities have a locker though, which I would leave my stuff in the car besides my identification personally, just because I'm never sure. You're not sure if you're going to be able to lock your stuff up. Just a few hints. You should never, not you, not the firm, file anything with FINRA that is incomplete or inaccurate so as to be misleading. Nothing you file should be misleading. The test wants you to know, how does FINRA handle the status of a registered person, whether or not it's an individual that's a registered representative or someone who maybe owns their own broker-dealer, when they are serving in the armed forces of the United States, so persons on active duty. So if a registered person should volunteer for or be called into active duty in the armed forces, they will be placed, as long as they give the NASD, which of course is now called FINRA, proper notification. They'll be placed in what we call inactive status. So a person serving in the armed forces. So they're not terminated. I suppose that's the most important thing in this discussion. They are not. Their registration is not terminated. So they are placed on what is called inactive status. So during this period of time, they cannot engage in any securities related, no sales of securities can be made. While they're on inactive status, if their contract allows continuing commissions to be paid, that is perfectly fine. So they can continue to receive commissions, but they cannot be engaged in the sale of securities during this time. While they're on inactive status, there's no fees that are due. So no fees that are due for the firm that's placed on inactive status or a registered rep, and there's no continuing education required during this period of time while they are serving our country. When they come back, they can reinstate their registration. They will not be required to pay any dues to reinstate. There is no admission fees that they will have to pay. So that's good. So they may receive continuing commissions, but they may not perform any of the duties that a registered person can perform. FINRA rules require that all representatives must be registered. So it's sort of funny the way the outline gives a rule, and then they give the same rule, but it's not a FINRA rule, now it's an NASD rule, or now it's a federal securities rule, but it's all saying the same thing. So some of this becomes repetitive. So any person engaged in the investment banking or securities business of a member who functions as a representative must be properly registered. So 6 or 7 and or 26 or 24 as we talked about. You can't be registered unless you pass your test. Member firms cannot maintain a registered representative's registration for a person who is not functioning as a representative, a person who's no longer active in the member's investment banking or securities business. So if the function that the person had within the firm has now changed so that they're not doing those things anymore, you can't just keep, it's not like insurance. With insurance, generally speaking, all you have to do is do the continuing education of your state to keep your license active, even if you're not. Now that's not true for all states, but it is for most states. Even if you're not actively selling insurance, most states will allow you to stay registered. That is not the case with your securities license. It's also not allowed for a member to make an application for registration for a person when there is not intent to actually employ the person. So I can't go, hey, friend who owns a broker-dealer, will you sponsor me to take the test? When I know I'm not going to go to work there. I would never, never, never do that. I can't do that. It's prohibited under FINRA rules. So if I'm going to work at a firm, then they can sponsor me to take the test. But if I have no intent of going to work there, well, then they can't. They can't. It would be a violation. Arbitration. I mentioned that FINRA has a code of arbitration, and arbitration is required by member firms, registered reps in member firms. Customers can force a rep into arbitration, and then depending upon if we've had the client sign a pre-dispute arbitration agreement, we can have the customer go to arbitration as well. It's a way to handle industry-related disputes, and disputes in the industry are usually about what, do you think? They're about money, of course. So arbitration is required. So as part of your registration process, Form U4 requires that you agree to go to arbitration. So members must provide associated persons with the following written statement whenever the associated person is asked to manually sign or initial an amended Form U4 or otherwise provide written acknowledgement of an amendment to the Form U4, which written can be electronic signature is fine. So it's this idea, just like if we're going to have, as part of the account opening process, the customer sign a pre-dispute arbitration agreement, we have to explain what it means, which that rule's covered way later on in the course. It's the same thing for you. The firm can't ask you to sign a pre-dispute arbitration agreement without explaining to you what it means. What are you signing up for? So this is the written disclosure that must be provided to you. Now, hopefully you read it. But in case you didn't, I'll read it for you. The Form U4 contains a pre-dispute arbitration clause. It is found in Item 5 of Section 15A of the Form U4. You should read that clause now. Before signing the Form U4, you should understand the following. Number 1, you are agreeing to arbitrate any dispute, claim, or controversy that may arise between you and your firm, or a customer, or any other person that is required to be arbitrated under the rules of the self-regulatory organization with which you are registering, which of course is FINRA. This means you are giving up the right to sue a member, customer, or another associated person in court, including the right to a trial by jury, except as provided by the rules of the arbitration forum in which a claim is filed. Number 2, a claim alleging employment discrimination, including a sexual harassment claim in violation of a statute, is not required to be arbitrated under FINRA rules. Such a claim may be arbitrated at FINRA only if the parties have agreed to arbitrate it either before or after the dispute arose. The rules of other arbitration forums may be different. So that's something for sure you should know. Sexual harassment suits, Employment discrimination lawsuits do not have to be arbitrated. So we can agree to arbitrate them, but they do not have to be arbitrated. They're really the only type of dispute that does not have to go through arbitration. So if they hired me to work in Denver and now they want to ship me off to Wichita and I'm ticked off about it, that goes through arbitration. If they want me to work a totally different shift than what I was told when I was initially hired and we're arguing over that, that goes through arbitration. If I don't agree as to how much they're paying me, they promise me something else, that goes through arbitration. But if it's a sexual harassment lawsuit or employment discrimination, it does not have to go through the arbitration process. So that's important. Number 3, a dispute arising under a whistleblower statute that prohibits the use of pre-dispute arbitration agreements is also not required to be arbitrated under FINRA rules. Such a dispute may be arbitrated only if the parties have agreed to arbitrate it after the dispute arose. Number 4 reminds you that arbitration awards are generally final and binding. A party's ability to have a court reverse or modify an arbitration award is very limited. Number 5, the ability of the parties to obtain documents, witness statements, and other discovery is generally more limited in arbitration than in court proceedings. Number 6, the arbitrators do not have to explain the reason for their award unless. So it's possible to get an explained decision if you follow these rules. In an eligible case, a joint request for an explained decision has been submitted by all parties to the panel at least 20 days prior to the first scheduled hearing date. So historically, you weren't always able to get an explained decision, but you can now if you follow that rule. Number 7, the panel of arbitrators may include arbitrators who were or are affiliated with the securities industry, or public arbitrators as provided by the rules of the arbitration forum in which a claim is filed. So we'll talk all about public versus non-public arbitrators much later on in the course. Number 8, the rules of some arbitration forums may impose time limits for bringing a claim in arbitration. In some cases, a claim that is ineligible for arbitration may be brought in court. So all of that is disclosed to you. It should have been in writing, because it's part of your U4 form filing. So this is saying, hey, look, go read that part of Form U4. And this is really what it's saying in better English. FINRA rules also impose upon you, not only you must pass a test initially, but ongoing you have continuing education requirements. So as a registered rep, we have CE. So there's 2 elements to CE. There's what's called the firm element of continuing education, and then there is what is called the regulatory element. So once you get licensed, that does not mean you're done learning, because this industry is constantly changing. One of my jobs is to keep up with this constantly changing industry, so I am never bored. So the firm element must be completed annually, and it really is done internally within your firm. The regulatory element must be completed within 120 days of your second registration anniversary date, and then every 3 years thereafter, every 3 years after. So the first one is kind of funky, within 120 days of your second registration anniversary date. The regulatory element is actually done down at a testing center. It's usually a case-based type of an exam where you read a case and then, knowing current FINRA rules, which are actually presented to you in the case, you answer the questions correctly. It's not really something you can study for in advance per se, short of do your firm element within your firm and learn about all the new rules as they change, and then really carefully read that case, and then you answer those questions. So what type of persons are subject to the firm element portion of continuing education? Any registered rep who has direct client contact. So you have to do the firm element every year, annually. Now, the member firm must maintain a continuing and current education program for all of its registered reps. The purpose of the firm element is to enhance the registered rep's securities knowledge, skill, and professionalism. All member firms must, at minimum, annually evaluate and prioritize its training needs and develop a written training plan. Certainly, a lot of firms hire a third party to do this for them, and then some firms will do it themselves. As a registered person, you must take all appropriate and reasonable steps to participate in continuing education programs as required. So you actually have to show up for the firm element portion of your continuing education class. The regulatory element covers securities industry regulations and ethics. So that's the one within 120 days of your second registration anniversary date and every 3 years thereafter. So know that one. If you don't complete your CE, you will be placed upon inactive status, and you must cease all of the activities that a registered person would do. You will be prohibited from performing any duties or functioning in any capacity that requires registration. If you don't complete CE, you're placed on inactive status. If you don't reinstate, do your CE, make everything all good again, after 2 years, what's going to happen? You're going to have to retest again. So always an important period of time to be aware of. If you're a registered rep and you take on a job outside of your employment as a registered rep, it requires a prompt written notice be given to the firm, and an amendment is filed on your U4, which we talked about that needs to be done within 30 days. So something that you do outside of the normal course of business as a registered rep that is active. So I sell hot dogs at Coors Field because I love baseball. I play piano on Friday nights at a local piano bar. Something I get paid for. It's not a volunteer job, and it's not passive. If I'm a limited partner in a limited partnership, I have no say in how the money is managed. I do not have to give prompt written notice to my firm. So it's only active employment outside of my normal course of business. So passive activities do not have to be disclosed. Once you get licensed, you'll find that it's really hard to make everybody happy all the time. And sometimes people will be frustrated, be angry, and they'll write it down. So member firms must keep records of all written complaints received. And then the firm actually must compile this data. So there's a difference between someone calls you up and is frustrated with you and yells at you on the phone and you make them happy and they go away. That does not have to be kept on file versus somebody that actually takes the time to write it down, whether or not it's an old-fashioned letter sent in the mail or via email today. Written complaints must be kept on file by the member firm, and then the member firm must submit to FINRA. Member firm must submit to FINRA when, these are things they like for the test, quarterly. Statistical data regarding these written received customer complaints. So written grievances made by customers, as well as securities-related written grievances by prospective customers, and any written complaint alleging theft or misappropriation of funds or securities or forgery. So that seems reasonable, right? That the firm should keep all of this on file, a record related to it. So how often do they have to submit a summary of the written complaints received quarterly? By when? By the 15th day of the month following the calendar quarter in which the complaints were received by the member firm. So after the first quarter of the year, by April 15th for the first quarter. Reporting requirements. There's going to be a whole bunch of different events that when they occur, require prompt notification be made to FINRA. In this rule, prompt means within 30 days, which is kind of strange. So they'll never have a question and say, when does it have to be submitted? Promptly and 30 days. It's going to be one of the two that you will choose. So these are events that require prompt notification to FINRA. But in the term prompt, we get actually 30 days, which feels really strange, I know. But it's the way the law is written, the FINRA rule, within 30 days. So each member firm must report promptly to FINRA, but in no event later than 30 days after each member knows or should have known the existence of any of these. Mostly common sense. If the member or an associated person of the member has been found to have violated any securities, insurance, that's a key, commodities, financial, investment-related laws, rules, regulations, standards of conduct of any domestic or foreign regulatory body, SRO, or business or professional organization. Prompt notification to FINRA within 30 days if any member or person associated with the member is the subject of any written customer complaint involving allegations of theft or misappropriation of funds or securities or of forgery. So think about that for a second. So when they receive a complaint in regards to those things, it's part of the statistical reporting data that the firm reports to FINRA quarterly. But when they get that complaint, they have to tell FINRA of that complaint promptly within 30 days. If the member firm or an associated person of the member is named as a defendant or respondent in any proceeding brought by a domestic or foreign regulatory body or SRO alleging the violation of any provision of federal securities law, insurance or commodity statute, or of any rule or regulation thereunder. If the member firm or associated person of the member firm is denied registration, prompt notification to FINRA, or is expelled, enjoined, directed to cease and desist, suspended or otherwise disciplined by any securities, insurance, or commodity industry, domestic or foreign regulatory body, or SRO, or is denied membership, or denied continued membership in any SRO, or is barred from becoming associated with any member of any such self-regulatory organization. Prompt notification to FINRA if the member or any associated person of the member is indicted or convicted of, or pleads guilty to, or pleads no contest. So I'm not good with Latin, but nolo contendere, I think is how you might say that. I have no idea. I'm pretty sure. So if they say that, it just means no contest. 2, so pleads no contest to any felony. Okay, so that's just any felony, or any misdemeanor that involves any of the following. So it's any felony, prompt notification. So if they're accused of, pleads guilty to, nolo contendere to, or a misdemeanor that involves the purchase or sale of any security, the taking of a false oath, the making of a false report, bribery, perjury, burglary, larceny, theft, robbery, extortion, forgery, counterfeiting. Don't do any of these things. Fraudulent concealment, embezzlement, fraudulent conversion, or misappropriation of funds or securities, or conspiracy to commit any of these offenses or substantially equivalent activity in a domestic, military, or foreign court. So any felony and then a misdemeanor if it has to do with anything where someone violates really moral standards, ethical standards. We hope we hire financial service professionals that don't steal money. So this is why this is something that requires prompt notification to FINRA. If the member firm or an associated person of the member is a defendant or respondent in any securities or commodities related civil litigation or arbitration, is a defendant or respondent in any financial related insurance, civil litigation or arbitration, or is the subject of any claim for damages by a customer, broker, or dealer that relates to the provision of financial services or relates to a financial transaction. And such civil litigation, arbitration, or claim for damages has been disposed of by judgment, award, or settlement for an amount exceeding $15,000. Okay, so what is this? So if the civil litigation is in regards to a registered rep and the decision is an award greater than, okay, award greater than $15,000, then we've got this prompt notification to FINRA within 30 days. So prompt notification to FINRA within 30 days. But if the civil litigation is not involving a registered rep, but instead is involving the firm, the member firm, then the prompt notification within 30 days is only required when the award is greater than $25,000. It's also required prompt notification to FINRA within 30 days if an associated person of the member is the subject of any disciplinary action taken by the member involving suspension, termination, the withholding of compensation, or of any other remuneration in excess of $2,500, the imposition of fines in excess of $2,500, or it otherwise disciplined in any manner that would have a significant limitation on the individual's activities on a temporary or permanent basis. So I know that was a long, exhaustive list, and I hate reading those to you. I can't just memorize them, and I'm never sure which one you're going to have. But the rule is that FINRA must be told right away, but within 30 days. And I know it seems contradictory, but it's actually how the rule was written.